Robby, what's on your radar?
Well, Kyle Rittenhouse's fate is now in the hands of the jury, following closing arguments and another day of courtroom drama yesterday that included more irresponsible behavior from the prosecutor, Assistant District Attorney Thomas Binger. While simulating Rittenhouse's alleged actions, Binger held the gun, pointed it sort of in the direction of the spectator section. It's not clear if he was pointing it at anyone specifically, but he put his finger on the trigger, and this was an idiotic thing to do, even though the gun was presumably not loaded. Quote, with the recent accidental shooting on a movie set in New Mexico still fresh on our minds, Binger sweeps the courtroom spectator section with the weapon and incredulously breaks firearms handling safety rule number 1. Never place your finger on the trigger unless and until you have acquired a target you may have to neutralize, wrote the New York Post's James Galliano. Yet another example of those prosecuting gun crimes with little understanding of guns. Now, MSNBC's Joy Reid totally missed the point, tweeting the following. So, according to right-wing Twitter, it's outrageous for a prosecutor to point an unloaded AR-15 toward the jury to demonstrate how scary that firearm is, but totally cool for a teenager to point a loaded one at people and shoot them. So it's outrageous to point a gun at another person and then put your finger on the trigger unless you intend to shoot. Binger obviously didn't intend to open fire on the courtroom, I hope, which is why his conduct was outrageous. This doesn't apply to Rittenhouse because he did intend to shoot. He did shoot. We're debating whether that shooting was justified. We are not debating whether he shot on purpose. We know that he did. It does not inspire much confidence, Joy Reid's punditry, in my opinion, that she doesn't understand the difference. But as for Binger, recall that he was savaged last week by the trial's judge, Bruce Schroeder, after suggesting that Rittenhouse's decision to remain silent after his arrest was indicative of his guilt. Let's watch that again.
Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that.
Contrary to what Binger wrongly asserted, refusing to answer police questions is both a fundamental component of due process and the absolute right choice for virtually everyone who finds themselves in such a situation. Even innocent people can accidentally incriminate themselves. If you're in this situation, you do not talk to the police, you ask for an attorney, even if you're innocent. Schroeder also dealt the prosecution a defeat on Monday, dismissing the weapons charge against Rittenhouse. This was big news. The Wisconsin statute that prohibits teenagers from wielding certain firearms is confusingly worded, and the judge decided that Rittenhouse's weapon was not covered by the law. So the decision stunned the prosecution, but Eugene Volokh, a professor of law at UCLA, argues that it was likely correct. Quote, just based on the news account and the statutes, the judge's decision seems correct, especially given the rule of lenity. When there is doubt as to the meaning of a criminal statute, a court should apply the rule and interpret the statute in favor of the accused, writes Volokh. So you can read more of his argument for why that's the case at Reason.com if you're so interested. But the basic issue is that the statute is confusing, and it's not clear if it mandates teenagers to seek hunting licenses in order to carry those sorts of guns. And if a statute is confusingly worded, then the matter should default to the defendant's benefit. The government can't write unclear laws and then punish people for not following them correctly. So with the gun charge tossed, the question for the jury really will come down to Rittenhouse's self-defense claim. Whether the three men he shot, Joseph Rosenbaum, Anthony Huber, and Gage Grosskreutz, pose a risk to his life, and whether his decision to fire on them was reasonable. In his closing arguments, Binger tried to argue that the fact Rittenhouse had fired multiple shots at Rosenbaum rendered the self-defense claim unworkable. Maybe the first shot was in self-defense, but not the next three shots were not. Of course, all four shots were fired in a single second, so it's not clear that this distinction will matter very much to the jury. Rosenbaum was trying to take Rittenhouse's gun away, and Rittenhouse believed that Rosenbaum would have used it to shoot him, the defense has argued. Bafflingly, the prosecution chose to mention Rosenbaum's eccentric behavior, which included setting things on fire that night, during closing arguments. I don't know why they wanted to bring that up. The prosecution also argued that while an aura of lawlessness and mayhem had descended on Kenosha during the evening in question, Rittenhouse chose to enter the fray with an AR-15, and that was itself a provocation. He, quote, brought a gun to a fistfight, the prosecution claimed repeatedly, using those exact words.
Clearly, if there is provocation, he's guilty.
But even outside of provocation, why do you get to immediately just start shooting? As Mr. Binger said, he brought a gun to a fist fight. And he was too cowardly to use his own fist to fight his way out. He has to start shooting. And let's just say, theoretically, that we think, that the 12 of you think that it is reasonable to have used force, deadly force in that situation.
But one of their own witnesses, Grosskreutz, who was shot by Rittenhouse but survived, previously testified that he also had a gun and that he pointed it at Rittenhouse before Rittenhouse opened fire. So how does that line hold true if the fight involved other guns, one of which was pointed at Rittenhouse? So it's anyone's guess how the jury will rule. But liberal cable news pundits seem to be preparing themselves for an acquittal. I watched a lot of CNN and MSNBC last night, and I was checking Twitter, and there's a begrudging, emerging consensus that perhaps the state has not made its case. You think? So that was gun. He brought a gun to a fist fight, but there were also other guns involved in this fist fight. Look, I get the point that it seems like what Rittenhouse did was, it can seem was disproportionate to the situation, that he shouldn't have been involved in the situation in the first place, but he's not on trial for being involved in a situation he should not have been involved in. He's on trial for homicide, and he says that he had a reasonable fear for his life, and so he was justified in firing his weapon. And the three people he shot, one of them has testified that he pointed his gun first, and one of them struck him with a skateboard, and the other was trying to take his gun away and had made threatening statements and had done threatening things. So the jury gets to decide, but that's the argument. It's not about any of the other things.
Right, because the state doesn't have a law. There are some stand your ground laws, and not every state has stand your ground laws, as they shouldn't. Because it encourages people to create violence, and then by creating that violence, create your own defense to then enact that violence. But there is a way that you can write the law that says that if you provoke the incident, and the prosecutor is referring to it, glancingly there, if you provoke the incident, then somebody responds to you. You can't use that response to say, oh, well, now I'm afraid, and so now I can kill you. The best example being, let's say, just a completely wild example. Hopefully this will never happen. Let's say, somebody goes into a school with an AR-15. They fire it off and then start running down the hallways. They haven't shot anybody. They're not necessarily planning to shoot anybody. But people see them running down the hallways. They've heard a gunshot. You now have people, because if you remember the Waffle House case, and some other case, there are heroic people in these crowds now who say, I'm going to risk my life to save the lives of dozens more people. I'm going to rush this shooter. And you often hear people saying, if I were in that situation, I'd rush the shooter. And you're willing to throw your body on the line to do that. So now somebody charges at the shooter. Now the shooter turns to them and shoots them. It's like, well, they were coming at me.
Right.
They were going to take my gun. And I think everybody could agree that that person is guilty of something. Now, the question for the jury is that scenario close enough to what Rittenhouse did? And I think because of the testimony he gave, that they were never able to refute, that he came there not simply as an armed guard for this car wash, but he came there to be a medic. I think the medic situation is going to play significantly into the jury's thinking, and that he wanted his gun for self-protection. The fact he was a lifeguard, the fact he did the medic work, the fact that he worked on some protesters, I think is going to divorce him from that scenario that I laid out.
And also, while I agree that he should not have come into this situation at all, he was walking away from trouble spots at several moments in time, especially what led to the first shooting. He was walking away from Rosenbaum, and then there was a third person who actually started Rittenhouse wasn't using his gun, he wasn't shooting, but someone else fired, and then that started this sort of confrontation. So I think
so he wasn't even the one that first fired. So I think which helps him as well. And the police, he was trying to get out. It's like, what are you doing there? Well, he testified he was trying to get out. They were not able to refute that. He said that Rosenbaum had seen him earlier in the evening and said, "If I see you again alone, I'm going to kill you. I'm going to cut your heart out."
And then the prosecution brought up Rosenbaum's kind of instability and eccentric behavior when they were in trying to be like, so what? And I think a lot of people are like, well, that does matter a little bit. But anyway, obviously it's up to the jury. We cannot predict what will happen. But the reaction from, I think I'm sensing a realization that this case was a lot weaker than a lot of people naively presumed. Not because the justice system is broken, but just because of the way this law is structured, which you might think is wrong. We need different, but like they have to decide on the facts of the.
Yeah.
So, but I'm looking forward to your radar coming up next.
All right.